Stuff. Alright. It has nothing to do with you. Alright, brother? Okay? It's okay. Honey, you're welcome here just like I am. Don't worry about these people. Alright, just do your thing. Alright, brother?
I just explained to that guy that
Maybe this
owners meeting he had, he threatened to grab me by the throat in front of witnesses, Dennis.
Yeah, I was here.
And he claimed that this email here threatened him and his daughter.
Sure.
So I gave him a copy and told
Well,
him that he wants to
disrupt.
and threatened me. That we could wait till after the meeting and I'll leave him that phone call.
It's okay, honey. Here you go.
I think he's one of Michael Schweitzer's people who likes to show us disrupt.
No, I'm better off with a heavy seat.
The other people, there's a show up.
He had that Atlantis Vasquez.
Plus he gets a better view of my shirt.
Yeah.
What's up? No, Steve, it's okay.
This video is okay,
Yes.
good one. What station?
CNN. CNN. Hello.
Oh, I still do. Sylvia's over here.
Sure.
It's no problem.
Yes.
Everybody, it's 7 o'clock. In case anybody doesn't know me, my name is Frank Greiser Jr. This over here is my father, Frank Greiser Sr., and my mom, Kay Greiser. We've been a resident here at Whittier Towers since March of 2010. And the reason I called this meeting is a lot of the owners have been getting, there's a dispute here, obviously, people know that, between Michael Schweitzer and myself. It's personal, but it's also become quite expensive legally because Michael Schweitzer filed a lawsuit against my mother and father and myself, claiming that we violated the bylaws and that it was necessary to protect the integrity of the bylaws by filing a lawsuit. That's not true. There was no need to file a lawsuit. This could have been worked out. It's kind of suspicious that this happens 10 days after I sent a second certified letter requesting to see the financial documents from the Whittier Towers, and the fact that I was writing a newsletter critical of the way this place has been run. And I just think that that's suspicious that 10 days later we get a letter from our attorney, from the association attorney. And it was a letter that said I had 18 days to vacate my unit, It wasn't a letter that said, hey, you messed up your proprietary lease and we need to correct this. It was, you have 18 days to get out if you don't file a lawsuit. And actually, they did file a lawsuit on October 4th. I filed a lawsuit in federal court claiming that they violated my civil rights, freedom of speech. And I did that basically to shame the association into dropping that lawsuit. They've been pretty adamant that they want to run this lawsuit through to the end. I invited the attorney here today. Sean Shepard was invited to speak at this meeting back in April when the owners were meeting. And he was told that he wasn't welcome, and actually the Broward County Sheriff's Department was here to keep him from speaking. So this is an opportunity for owners to get the other side of the story on the lawsuit, because there was a December 2nd letter that was sent out to the owners. If anybody didn't get that letter, I do have copies here. And this was a letter that was addressed to the owners, claiming that there needs to be a special assessment of $60,000 to pay for legal fees involving the litigation between my parents and myself. And there was also some misrepresentations made that I want to have our attorney address and give you the other side. There's always two sides to a legal fight. In the budget letter, the management assist is the management company. We've been having problems with the management company. The owners have asked to replace the management company for years. And for some reason, we keep them on, and I believe they allowed funds to be taken from accounts where they shouldn't have been taken to pay for legal fees, because we've always budgeted $2,000 in legal fees. Last year, we budgeted $5,000 because Michael knew the lawsuit was coming. And this year, they've spent $65,000. So we have some questions on where that money came from, and was it properly appropriated. We would like an accounting of where the money's been spent, because the owners have been kind of kept in the dark. We've heard things like, we'll get our money back when the Greisers lose the lawsuit, and we don't know how much money's been spent to date or where it's come from. And we really would like an accounting of where the money came from. And we did find out, my father has become pretty good at understanding our bylaws. When this first happened, we didn't understand the bylaws. A lot of owners get the bylaws and they don't read them. It's really important for the owners to read the bylaws, understand the bylaws, and also have the board of directors read and understand the bylaws, because they are complex, and if you're going to bring an action against somebody for violating the bylaws, you need to make sure that you're adhering to the bylaws too. And apparently, the board of directors can be elected every year in the original bylaws, and they haven't been running for election every year. And actually, when this lawsuit was filed in October of 2012, Michael Schweitzer's term as president and director expired, and so did the terms of 4 other board of directors. So these are some issues that we want to bring to your attention too, because they claim that the bylaws were amended in 1976, and they showed the minutes of a meeting where it was amended. But when you amend a contract and you continue using the old contract, like the bylaws that were given, the amendment is no good. The owners need to know what the changes were. We're not psychic that we can think that it's been changed in 30 years. I mean, if that's the case, there could be multiple changes that affect us. We really need to know. And 10 years ago, the board of directors had a law firm evaluate our bylaws, and they did write a recommendation that we tighten up our bylaws, because a lot of the language in it is no longer applicable, and no one's done that. And before we should file lawsuits against people, we should really understand the bylaws. And also, I lost my train of thought there, but that's pretty much where we are. And I just wanted our attorney, Sean Shepherd, to be able to address the lawsuits and how nobody wins in a lawsuit. You have losers and losers, and really you should do everything you can to avoid a lawsuit, and we failed that. And we failed along the way. We failed to work things out. We failed when we had the mediation in front of a judge. And my father and mother offered at that mediation. Okay. Then basically, I think I should turn it over to Sean Shepherd, who's our attorney. And then afterwards, if you have any questions for Sean, he'll be happy to answer them. Sean?
Thanks. There's a few different lawsuits, and the letter that was sent out by the association says that there's no fewer, I think, than 6 lawsuits filed by the Greisers, and that's just simply not true. The initial lawsuit in this case was filed by Whittier Towers against the Greisers. That was back in October of last year. At that point in time, the Greisers had not filed anything, had not done anything legally, and the association took it upon themselves to attempt to both evict Mr. Greiser Jr., who's a first blood relative of Francis Greiser Sr. and Marion Greiser, and cannot be evicted from the premises. He has a right to occupy regardless of whether there's any opposition by the association or not. But that aside, the association took it upon themselves to file an action against the Greisers to seek that relief. My assessment of the situation, if you look at the bylaws and the governing documents of the association, an eviction is not something that the association is ever going to prevail with because they can't. Mr. Greiser Jr. has a right to occupy the unit as he is the first lineal descendant of Francis Greiser Sr. and Marion Greiser. So the eviction component of the remedy the association is seeking can never be granted. And that's language that was just chosen by the forefathers of the governing documents, and it's in there, and there's nothing that anybody's done to change that. In any event, the first lawsuit was filed by the association. The Greisers did not file a counterclaim to that lawsuit. They simply filed an answer in their affirmative defenses to that lawsuit. They're defending themselves against that lawsuit. And that's the primary litigation here that is being fought. There was a mediation that was attended that did not resolve the case. I have invited a waiver of the privilege of what happened at that mediation so that the membership can be aware of what happened there. I have not received a response on that invitation to waive the privilege so that everybody can understand what happened there. But the Greisers remain willing to waive that confidentiality of what happened there so that everybody can be aware of what happened there. But until the waiver is reciprocated by the association, I'm not allowed to talk about the substance of what happened at that mediation. No fewer than 6 lawsuits is simply an untrue statement. Mr. Greiser Jr. filed a federal action, which is the first lawsuit that was filed by the Greisers, seeking to protect his rights to freedom of speech in the federal lawsuit, and that was dismissed. He appealed that decision in the federal court, which is not a lawsuit. It's a continuation of that same case. There was one other lawsuit filed by the Greisers in county court on separate matters regarding the election of individuals to the board of directors and officer positions. There was a motion to dismiss that litigation based upon an assertion that the statute requires an arbitration to be filed on those issues. The court dismissed the lawsuit as to the election issues that required that an arbitration be filed, but did allow the Greisers to proceed with other counts in the county court, which they are doing. And that case has not been dismissed. That case is pending. The letter from the association indicates that all of the cases filed by the Greisers have been no fewer than 6 cases have been filed and all of them have been dismissed. That's not true either. The county court case is proceeding forward. It has not been dismissed. And the arbitration, which was necessitated by the association objecting to that being heard in the courts, is proceeding on a different path through mandatory statutory arbitration. With that said, that's the magnitude of the litigation that's ongoing. There are not 6 lawsuits that are pending, or there are not 6 lawsuits that have been dismissed. There is a circuit court case that the association filed against the Greisers that we are defending. There is the county court case filed by the Greisers, and there's the appeal of the federal court case that's going on. And all of this stems from the initial lawsuit from the association deciding what the best course of action at this point is to file a lawsuit to attempt to evict the son of 2 owners for being added to a proprietary lease here at Whittier Towers. So we did take a deposition of Mr. Cousins most recently, and we asked at that deposition what the expenses have been to date regarding litigation of these cases. And although he did not know a specific amount, he indicated in his deposition that the amount of litigation that had been expended was $35,000 to $40,000. So there was some concern with the number of $65,000 is put out in the letter that was the litigation expense that is significantly different than what the deposition indicated last week that was taken with Mr. Cousins. And we have indicated in a letter to the association concerns about not only the terms of the officers and directors exceeding what the bylaws and governing documents required to be every annual elections. In addition to that, concern that both the special assessments and the general assessments are way out of control at this point, and the feasibility of that to the owners here is of great concern to my clients, being owners of 2 units here, and I'm sure it's concern of everybody else who's an owner here, because these sums are significant. So I just want to dispel some of the false information that's been put out by the association regarding the litigation. I've been a litigator for 18 years. I couldn't tell you, nor could any attorney who's been practicing for any period of time tell you with any certainty what's going to happen in any litigation. Nobody can guarantee anything is going to happen. There are issues factually and legally from the Greiser's perspective that they feel have merit. There's issues that the association feel have merit from their side. At the end of the day, the judge is going to make a decision on what's going to happen with this case. It could be a win for one side and a win for the other side. It could be an entirety of one party paying the other party's attorney's fees. And it could be a hybrid. It could be several of the issues are won by one side and several are won by the other side. And the judge at the end of the day says everybody pays their own attorney's fees and costs. I don't have a crystal ball. And nobody can guarantee how any litigation is going to go with regard to the prevailing party standard. But the statute says the prevailing party in litigation is entitled to an award of fees in the end, and it's up to a judge to decide whether to award that. That's where we are. The only case that's set for a tentative trial date right now is the circuit court case that was filed by the association. The county court case is in its early stages right now, and the arbitration is in its early stages right now. So that's where we are as far as litigation is concerned, and my comments on what I thought were misleading statements in the association's publication to the membership. So, if anybody has questions for me, I'm happy to answer.
Excuse me, Council?
No.
Just to let you know, I moved in here 2 years ago. I'm a single dad with 2 daughters. I stepped in a situation, we didn't know all this was going on. I've been a resident in South Florida for 32 years. I don't function by threatening anybody. I've never threatened anybody. That's not the way I was brought up. Just for the file, I want everyone to know that. I'm here to raise my daughters and then co-labor and try to live within a community where we are working together. And so just for the file, just so you know that. I wasn't brought up, I don't threaten people. I have plenty of stuff going on with my 2 little girls, and that lost my brother 4 years ago to suicide. We're in recovery. I want to raise my daughters in a peaceful place, and therefore that's how I roll for the record. Thank you.
I might add that that's an outright lie. I was here when that person threatened Frank Greiser Jr. So were some other
Yeah,
people.
so
in
was
this
I,
room.
when you threatened them.
Yeah, you threatened to kill him.
Yeah,
Screw him in front of
That kind of
I-
blindsided me, because I had no
That's-
idea where that was coming from.
I've never said that.
anything.
You did, sir.
Yeah.
And you're a liar then, you're a liar now.
Counselor, has Frank Greiser Jr. been an approved donor? Did he go through the application process?
That's part of what's being litigated right now, and the judge is gonna determine that.
Okay.
There are both legal and factual issues that need to be determined by a judge, and that's what the fight is about. The association is saying he did not follow the proper procedures, they're saying they did follow the procedures, and that's where the factual dispute is at issue before the judge.
Okay, got it. Thank you.
Hi, Sean.
Hi.
I just want to know why they say the Greisers aren't willing to work it out. Why can't he just do the security check or whatever and get all this out of the way? And how long is this going to go on? And next year's going to be another 100,000? And when's it going to end?
Right, and it's, unfortunately, I can talk to you about stuff that did not happen at mediation. Outside of mediation, there's a privilege that attaches when you go into mediation, it's court ordered.
I guess it's just a general
Yeah,
type
generally
question.
speaking, outside of that, and just talking in a vacuum, I would say that there's not been a lot of discussion outside of that about resolving the case, unfortunately, but, and it's my opinion, and I said this to Mr. Collins, I'm not saying anything I didn't say to him personally, you know, this is something I felt could have been resolved very simply instead of filing a lawsuit by just, you know, having a meeting like this and sitting down and saying, look, you know, you didn't do this, you know, why don't we just check the box and get this done and do it the way we want to do it and avoid filing a lawsuit. I wasn't involved at that stage. I came into the case after.
I guess it's a question for the other side too.
Sure.
I just wanted to,
In all fairness to everybody, you know, that 99% of litigation is stuff that could be resolved before it even starts. And, you know, this is an ideal situation where that probably could have happened.
But do you have like an idea, like another year, another 2 years?
I have cases that have been pending for many years, and it's just unfortunately the way you end up, like, we went to court on this case, and we were set to go to trial in October, November, and we showed up and there was 50 attorneys in the room for their cases to be tried, and our case got passed.
Well, I had a sale on my condo in August fall
Right.
through because of all this. There's 8 units for sale right now.
Yeah.
No one is gonna buy anything, and the property values are decreasing.
yeah, that's what I wanted to mention. This really hurts the owners the longer this goes on. No one's gonna be able to sell their unit to a dysfunctional association. And Paul was honest, and he had heard through the grapevine that there was gonna be a special assessment of $2,500. He notified his Caldwell banker realtor, who contacted the management company, and they said, yes, there was a special assessment coming. And Paul was upfront, and his sale fell through because of that reason. Actually, it fell through, what, Paul, 2 days before?
Yeah, like a week.
2 days before, a week before settlement, it fell through. So this really does put a hurt.
So I guess everybody's tied up indefinitely.
I appreciate that, and that,
I'm just trying to let
yeah.
who's ever watching the video know.
What, if anything, are you permitted to say as to the possible fiscal fiduciary irresponsibility or illegality of paying funds that are specifically earmarked for the land lease and seriously jeopardize all of our ownership positions. And they've been admittedly used in this assessment letter to pay legal fees. Are you allowed to give any opinion on whether or not that is a fiduciary violation?
I would if I had all the information. I don't have all the information. And if you read the letter line by line like I did, it's not, there's no specific reference to, there was $41,682 that was paid from this fund to pay legal fees. There's not that clarity in the letter. So I don't want to jump to conclusions. That's why I had written a letter to the association asking specifically, how much in legal fees have been paid for all these cases? Where did the money specifically come from? When was it paid?
Are they responding?
It was very recent, so I can't say that they failed to respond. I just wrote the letter 48 hours ago. So
I
wouldn't
have an
expect a
official
response.
letter given to me by one or more state regulatory boards that I have filed complaints with. One of the forms is a letter legally demanding financial records, and it sets out the penalties if they don't comply within 5 or 10 days. Would it be in my interest to do that, or would that simply overlap what you're already doing?
And the association attorneys here, I don't know if they intend to respond to that inquiry. If they do, perhaps the easiest thing to do is just to send out to the membership, an accounting of how much has been spent, when it was spent, where it came from. That would be the simplest thing, in my opinion, to do.
Yeah.
But, until that happens, I can't
Is there
appropriately say to you, I think there's been a violation of this or a violation of that without knowing where it came
Is
from.
there a legal reason for them to deny that request?
I think the membership's entitled to know that information. My request is very hyper-technically not a proper request because I'm not an owner. But I'm hopeful that the formality of asking for that is something that's not necessary.
Excuse me, I'll get the letter and you can give it to me.
Okay.
I'd like to ask a question. We had, prior to these lawsuits coming forward with all the expenses, there was, I think it was 23 owners here that signed a petition to drop all these lawsuits, that we didn't want to get involved and we weren't paying for our lawyers, court costs, et cetera, et cetera. And as far as I know, the board of directors did nothing about it, right? And then the next question is, all right, supposing in the end that this comes out that either party is won. As far as I know, Michael Schweitzer is the guy that initiated this lawsuit against the Greisers, right? And to evict them and whatever. Now, if it comes out that he was not elected properly as the president of this board, would we still be responsible for the money?
It's a legal question that requires, the advice of a counsel, but in my opinion, if somebody acts outside of their authority to do something, there could be some personal liability there. But that would be something that would need to be proved first. And there's a lot of dots that need to be connected to do that. But if they were all in fact connected, and it turns out there was, somebody stepped outside of their authority to do something they weren't authorized to do, then perhaps personal liability could attach to that point. But then, again,
Yeah, right, yeah.
My name is Leonard Young, I'm the owner of 202. And I prepared a statement, I'm trying to get my thoughts organized, and I'll read it to you. Never in the history of Whittier Towers has an owner been sued for anything other than delinquent payment, and certainly never for writing a newsletter, as in this case. Now, I have the correspondence to prove that, if you want to see it. I want to see the record of when and which board members voted for this lawsuit. I believe there was no vote, and it was initiated by Michael Schweitzer alone. He should therefore alone be charged with the expense. And additionally, if we were to hold a vote of the owners today, I sincerely believe there would not be even a minority, large minority, who would vote for it. They were blindsided by this because they were never told by our management that there was anything like this at all. It seemed to be like a minor paperwork thing. Now, if he is signed on to his apartment by law, and I looked up in the Broward County records, and he is listed as an owner, if it's legal by Florida, why isn't it by Mr. Schweitzer?
The association's position, as I understand it, and they can correct me if I'm wrong, is that they feel that the governing documents require an application to be submitted for a background check to be done, and that is their position that they follow that procedure uniformly with everybody, that everybody submit an application, everybody has a background check done, and that there's a board meeting to approve or disapprove of an application, and they feel that that process is not followed by the Greisers, and that's what the lawsuit is about.
I don't think they're supported by the owners.
It's
And we should take a vote of the owners. And if the owners disapprove of it, we should not only throw out the lawsuit, but perhaps Mr. Schweitzer as well.
Well, there's a democracy to this process, and, that's something that the membership can unify and gather, the necessary votes to do that.
That would be my direction.
But Dick just said we did that last year and nothing happened.
Well, there's a method by which to get that accomplished, and certainly if you get the requisite number of votes in the membership together to do that, it's certainly accomplishable.
One point I think we did touch on this. I was approved to live here by the prior board, President Michael Correa. Michael Schweitzer wasn't at the approval meeting. It was held right here in the office with my mom and dad, myself. And that this really wasn't a transfer of proprietary lease. My mother and father own 2 units. They're still on both units. I was added as a sibling, and it's done all the time in here. And I think we proved of the 50 proprietary leases that there's 8 other owners that just added a sibling, and nothing was made about it.
And I didn't finish my comments, but our position is factually that they did in fact follow what was required of them to do, and that Ms. Roberts, who was the secretary at the time, advised Frank Greiser Jr. what to do, that all he needed to do was go down and get the requisite signatures on the proprietary lease and record it. He followed her instructions and did that. So this is not something he just made up and went out and did. Factually, he believed he had the authority to do it because he met with an officer of the association and followed the instructions that she provided to him. And aside from that specific instruction that he followed, it's our position factually that the association has not uniformly applied the requirements that they're seeking to impose against the Greisers now. So,
Council.
yeah.
Just like I mentioned, I come in here two years ago, we bought a unit. I mean, Frank, I didn't know him. Why, the thing is, Frank, why don't you just go through the background check? You seem like a decent guy. We all did.
They're not letting them. Wake up. This is a personal vendetta. That's all it is.
Got it, okay. Remember, I came in here not knowing anybody, and I'm still getting to know everybody. So that's fine.
Did you go through a personal background check too? I mean, does everybody? I never read the bylaws for background checks. I have no problem with my
I mean,
background.
I have no problem.
I can
with you,
pass the
I'm just
background.
saying. I think everybody did. You seem like a decent guy.
I can
don't know
pass
why-
the background check. I have no
Then why
problem.
don't you just do whatever they're asking?
They're
That way you just-
not letting him.
They
do
don't want me
that.
here.
They
Do you
don't.
really think
They
that-
want to
Okay.
kick him out.
All right.
He'll spend anything to get rid of him.
We've already spent $100,000.
He's the king of Whittier Towers.
Sir, if I could interject at this point back to the fiduciary responsibility issue. I have filed several complaints against both the association and the property manager. Those matters are now in the legal department of the state regulatory boards. Along the way, this issue of refusal to disclose financial records came up, and they sent me a form because they said that the form that I originally sent to them as part of the complaint was not sufficient or proper. They said, well, they would send me a sufficient and proper form. And it seems like at the moment this form is particularly relevant in as much as you pointed out that there hasn't been an actual disclosure of X amount has been spent on legal fees. And in order to determine if there is a fiduciary violation, we would need to know that. So obviously, as a disgruntled owner with Schweitzer and the rest of the board, I want to establish that. Now, this letter, I'll read it and then so that the videotaping and so on has it on the official record, and then give it to you, although I would like to back it. It's the only copy right now that I have. Official records request form. This was furnished to me by the Florida State Board that governs cooperative and other forms of homeowners associations in Florida. To Board of Directors of Black. As a shareholder and member of the association and pursuant to section 719.104, paragraph 2, Florida statutes, the undersigned hereby requests to inspect and copy the following official records of the association. And these lines 1 through 10 blank, which the requestor is to fill in. This written request is made pursuant to section 719-104, paragraph 2, Florida statute, and has been sent by a certified mail. Florida law requires that the records of the association shall be made available to a shareholder within 5 working days after receipt of written request by the board for its decision date. Further, quotation marks, the failure of an association to provide the records within 10 working days after receipt of a written request creates a rebuttable presumption that the association willfully failed to comply, unquote. Please provide the undersigned with an appointment to review the financial records requested above. I will call you for the appointment time in the next 5 days. Thank you. Signature, printed name, address, phone number, and date. So my question would be to you, if you would be so kind as to furnish me with what would be, since you are not a registered owner and entitled to submit this form and have it responded to, if you would tell me what would be in the best interest of the people pursuing this side of the litigation in this request, and I'd be happy to send this in and
Sure. I could write on there what I think. You know,
Dennis.
if you do that in on a separate piece of paper, because I need that.
Dennis, for the file, is that a name of your new company, the Sugarware?
What's that?
Is that a name of your new company, the Sugarware? What does that mean? I mean, I was reading that. What is
Why
that?
would that be of interest to you?
Why
Or
not?
what does that have to do with what's going on?
It's just a question for the file.
Okay, well, leave it to your own imagination.
Okay.
I would be hopeful that in light of what's being voted on at the meeting, that I think is on the 16th, right?
Yeah.
That the association would provide some kind of accounting of those numbers, because it's a significant amount of money. In order for there to be a fruitful discussion and
Yeah.
vote on the inside, the membership would receive some accounting.
I mean, obviously, they're gonna drag the feet, it's not gonna be available by the time that meeting is, but at some point, it must be made available, so.
Well, hopefully.
My initial thought was simply to say, all records of payments made to attorneys and for what legal proceedings.
Sure.
Already paid, now sitting on the desk of the property manager or Schweitzer to be paid. And of course, they're not gonna respond to what do you anticipate, but, you know, at least what has already been paid and what is in the inbox to be paid.
I understand.
So do you think that would be proper and sufficient to our interests?
Yes, I do. And I think that's somebody would have to.
So can I ask you
And you want me to just take the paper back and I'll?
Yeah,
Okay.
I could write with, I wrote a pretty concept, comprehensive.
Yeah, if you want.
list of,
Might have some kind of outline.
Sure, I'd like to
email
answer
to
your
them.
question. If this special assessment is kind of ran through on the 16th, along with the the monthly assessment, which you said was a problem, do we have rights to stop that and possibly refuse to pay, possibly depositing our funds in the escrow account?
Well, these are if questions, and, you know, first of all, this is just a proposed thing.
Well, I mean, they're kind of desperate here. They're saying, on the 2nd, we're gonna have a meeting on the 16th, we're gonna pass this thing, and you gotta pay by the 31st, because we need money to replenish the funds. So it's kind of like rush, 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 rush. And I've spoken with a lot of owners who do not want to pay the special assessment and do not want to pay the illegal increase, and want to possibly pull together as owners and establish an escrow account to put the money in until certain conditions are met, like give us a complete accounting of how much money was spent, who authorized the funds to be taken out of certain accounts, and things like that, just to put owners' mind at ease. Because like an owner told me, they say they need $65,000 to pay back the money. That doesn't mean there's another $30,000 in legal bills sitting on the desk in Michael Schweitzer's office. We don't know, he won't tell us. He just wants to keep saying that, don't worry, you're gonna win at the end and we're gonna get our money back.
Well, there's two different kinds of assessment being proposed here. The first if is whether or not they're going to be approved. If they are approved, they have to be approved with the proper channels, they have to be approved by the proper board. There's the issue of contention you have in your litigation that they're not a proper board, that, you know, they're required annual elections and they've only been doing 3-year elections. And then there's the issue of the governance of the special assessments and the general assessments. And those assessments are governed first by Florida statute and second by your governing documents, what your bylaws say. And any increase to your general assessments by a certain percentage requires a vote of the membership as well. And I encourage you to be at the meeting to both talk about the issues and demand what you think is reasonable information to make educated decisions, and then to vote on the issue to the extent you're provided an opportunity to vote, and to lobby with your board of directors not to approve things that you feel should be approved, and to exercise your rights of democracy in that regard. To the extent that those rights are not provided to you and you feel that, you know, there's been a violation of your rights pursuant to the governing documents or Florida statutes, that there's been an increase in the general assessments that exceeds the percentage that requires a vote and they don't give you a vote, or to the extent that you feel that there's a special assessment that's been illegally levied against you, it's up to everybody to make their own decisions on how they're going to proceed with handling that. You know, but certainly you have rights to do whatever you feel is appropriate, you know, after the meeting.
Excuse me. Wouldn't the owners have a right to vote on this issue and reject the lawsuit?
My understanding is that in light of the increase that they're requesting, that requires a vote, but that is dependent upon whatever vote is presented. It could be after the meeting and a discussion regarding the meeting that an increase of a lesser percentage is asked for. It all depends on what is put to vote. And I would be hopeful that the board, regardless of whether or not a vote is required, would listen to the membership and follow what the membership would like them to do. And certainly there are, from a board's perspective, there are, you know, concerns that any board would have regarding dealing with budgets and things, but transparency should be an issue that should be encouraged by the board to come forth and explain to everybody exactly what you're dealing with, and not dealing with, you know, just generalities and saying, well, we need $65,000, not specifically where it's coming from or whether it's been paid or where it's been paid from. So.
How, do you have to be here physically? People aren't even here. Like, how do you have a vote?
Well, you could have proxy votes, for people who are not here, and people who are here can actually vote. It's just a normal meeting wherever you have votes.
But if there's only 5 of us that go, and you say no one else is here, what do we do?
The law allows you to obtain proxies and provide proxies for people.
Just
who are
like
here
the
to vote.
elections that are done, so
On your behalf.
So
To
we
the
don't-
extent there's a vote, to the extent there's a vote.
are we allowed to vote on
And like I said, it depends on what is proposed. If there's a proposal that requires a vote to be had pursuant to the statutes and the governing documents, you have to put it to vote.
it? How do you make that proposal?
It depends on the level of increase in the general assessment. If it's a certain percentage, they're required to have a vote. They can't just, for instance, say, well, the new monthly assessment's gonna be $10,000.
Well, that's what they did. That's what they did.
No, I mean, just make up a number. There has to be some democracy to the whole process. So. And I'm hopeful that the board will acknowledge that. Yes.
If I understood correctly, the reading of the old bylaws, because nothing has been updated in the county, that Mr. Schweitzer Jr., being a lineal descendant, would be entitled to live in whatever unit his folks own. Is that correct?
Right, that's right.
Yes, and and that's what I was speaking to earlier. The association is seeking to evict him, which eviction is a remedy of forcing him to leave. And regardless of what happens with this, application and the proprietary lease and the ownership interest of a member, his right to occupancy is secured by the governing documents. And it says, regardless of what application process you have in place and what requirements, what hoops you make them jump through, he's a first blood lineal descendant of Francis Greiser Sr., Marion Greiser, and you have to approve him. You don't have the discretion not to approve him. And it's the way they're written, the governing documents, and it's something that I was hopeful the association would acknowledge is a losing battle. But regardless of what happens with this litigation, I don't see Mr. Greiser Jr. being kicked out.
But it seems to me that it's a moot point. If it's
my
been there for
opinion
more
as
than
well.
50 years, it's a moot point.
It's my
He
opinion.
belongs here.
$100,000 per point.
Yeah.
For now, how about a year from now?
That's what I'm saying.
Another
Yeah, 100 a year per point.
Who's gonna buy a unit here with a maintenance fee of $600-700?
Well, maybe Schweitzer has some more friends.
Yeah.
The other question I have on this letter that was written December 2nd, looking for this special assessment and the anticipated deficit of 2013, the balance of the assessment used to recover unbudgeted maintenance costs experienced in prior years.
And that was part of my concern, is that those things are grouped together in this $65,000. And it was unclear to me. To me, it appeared as if they were trying to allocate the $65,000 being attributable to the Greiser litigation.
Right.
But in fact, I think it's a blend of a whole bunch of things.
It's not clearly.
And it should be very clear that, okay, we've spent this much on litigation with the Greisers, it's X amount of dollars, and there's this much of a shortfall in maintenance fees from prior years, and there's this much of a shortfall in anticipated budgets for the coming year. It should be clearly spelled out for the owners.
Well,
And
it
that's
would
one of
seem-
the things that I've asked to happen.
It would seem that if there were deficit in prior years, they should have been addressed in the subsequent year. Deficit for 2013, understood that it could be addressed for a budget for 2014, but not something prior to that.
Yeah, I would agree with that.
Any other questions?
Yeah, if the board, the 5 people on the board approve all these increases, can we contest it or whatever? Legally?
Again, it depends on what happens, and it's hard to speculate on what.
Just say
what's going to
it
happen.
gets rubber stamped, then what
If it
happens?
gets
Is it legal or not?
If it gets approved and it's not voted upon properly and it's above what is required to be voted upon and they don't vote upon it, then you have a right to contest that. But I'm hopeful that in light of